condemned Claudia Mo for her actions. I hope that we would act as a good role model. I submit this bill. Thank you.
Ms. Dr. Priscilla Leung, I speak in support of the Discrimination Legislation Miscellaneous Amendments Bill 2018. Many members have spoken. Under the proposal, mothers who are breastfeeding will be protected. Well, when I had my 2 children, I also advocated breastfeeding. I work in a university. I had my own office. Still, when it comes to achieving the goal, or as a mother, if you want to do what you want to do as a mother, it's still very difficult. New mothers have a lot of things to do, and they are subject to tremendous mental pressure. If there is no support from families and from the place they are in, a lot of people I know have given up to breastfeed. A lot of mothers would feel that they have failed their children if they can't or don't breastfeed, because researchers show that children who are breastfed will have a better immune system. I had to go through a bit of mental struggle. With my first child, I was very determined, but that did not reduce the difficulties I encountered. I persisted for about half a year. I persisted again with my second child because I do not want them to think that I give them different treatment. Now times are different. We can give them support. Hardware is important. I remember that Miss Eunice Young asked for these facilities to be built in LegCo. There are some personal assistants of our colleagues. They are 7 to 8 months pregnant. We asked them if they would like us to try to get maybe a couple of rooms to be converted to breastfeeding room. They were very enthusiastic. Well, some of them were reporters. Reporters nowadays can work while they are pregnant. This is their workplace. If we have another opportunity to have a discussion, maybe we can provide 1 or 2 breastfeeding rooms for people who work here that are not legislators. The second thing is in relation to enforcement. Legislation is one thing, enforcement is a different matter. I have been following these 4 pieces of discrimination ordinance. We have Sex Discrimination Ordinance, Disability Discrimination Ordinance, Family Status Discrimination Ordinance, and Race Discrimination Ordinance. I have assisted people who request for assistance under these different ordinances. Well, they have very often been turned away. The EOC uses different approaches at different times. I hope that, with the passage of the bill, cases that have occurred recently will be properly dealt with. If you require the aggrieved party to get a lawyer to take the matters to court, it will not be a good thing. We will follow up on these 4 pieces of legislation. Well, under the Disability Discrimination Ordinance, it includes people who are ill, say under Section 6. I have encountered some cases. Parties have contracted communicable diseases. They have to be protected. So do their associates. Well, under Section 46 and 47, it says that if in a public event someone incites hatred, discrimination, and despise towards another person, it is an offense. We have taken up 2 cases. They are police officers. They have contracted COVID-19. They themselves and their families are the subject of ridicule. On the internet, there are posts said that they hope that the whole family would die, or they hope that the entire police force would contract the illness. They do need the aggrieved party do need our help. We tried to approach the EOC. In a few hours, they told us that it's not they will not handle it. Well, for breastfeeding women, sometimes the discrimination comes in a form of just a look, or nuisance, or sneak photos. Well, I talked to an ex-officer of the EOC. They said that, of course, it is a reportable case, but still, we're turned away by the EOC. Let me give you another example. The Race Discrimination Ordinance. Well, in year 2000, when the bill was drafted, I came to give my comment. Well, there is not just direct discrimination, there is indirect discrimination, say for example, on the grounds of the place of birth, on your accent. You have encountered a lot of cases of serious discrimination of people who come from the mainland, and it's different from prejudice. Please come back to this point. We have Mr. Eric Zhang, who has just joined us. Well, I have had some kind of contact and cooperation with him. Please come back to the point. Well, if you're going to go through other legislation, you will need more than 15 minutes. Come back to the point. Yes, I want to tell the Secretary that discrimination and prejudice are different. Well, when it comes to discrimination, there is employers to employees, teachers to students, someone who provides services, say for example, legislators. That's discrimination. What about prejudice? Well, if I give a look towards someone, then that definitely is discrimination. Education is also very important. It is the first step to combat discrimination. there's a report from the EOC. They talk about indirect race discrimination that includes one's accent. There are also some articles published by the United Nations. When we look into discrimination, we have to take a macro view. Now we amend the sex discrimination ordinance. Well, some people talk about sexual orientation discrimination, but sex discrimination is different from that. For sex discrimination is gender. Well, breastfeeding women fits the bill, but if it is sexual orientation discrimination is a different thing. We do not agree with legislating against it, because there are many examples from the world that showed us that if we use legislation to deal with controversial matters, say whether we should legislate to protect sexual minorities, there'll be problems with provision of services or shops. Well, there are 40 or so secondary schools in the UK that prohibits girls from wearing dresses or skirts. In Canada, well, they have also cited examples because they don't want to offend anyone. Education is very important. Well, there are some blatant discrimination. There are also reverse discrimination, say in the show business. Some people don't dare to say that they are opposed to same-sex marriage. When we talk about amendments of miscellaneous ordinances, legislative amendment, promotion as well as education cannot be segregated. We don't want to take people to court, and you may not succeed anyway. Of course, well, there will be pressure on your superior. Provision of facilities and hardware is also very important. Well, the controversial sex discrimination, sexual orientation, and reverse discrimination, that's important too. I have seen some API. They only talk about sexual orientation discrimination in a one-way street. It makes it out like a lot of people are subject to sexual orientation discrimination. No, it's only a minority. Well, it involves a lot of things. Even the marital system. Please come back to the point. Yes. With these discrimination legislation, whether they are miscellaneous or not, whether they are implementation or not, whether it's different approaches at different times, well, of course, we first go to the EOC. You have to show us, you have to express more concern. If it is discrimination ordinance, we have to be fair. I so submit.
Mr. Shiu Ka-chung. Thank you, President. In fact, we don't have to make things complicated, and sometimes when we try to make things abstract, you don't know why. Well, being prejudiced is an opinion, but then for discrimination is an act. So, President, I support equality to everyone, and therefore I support anti-discrimination work. That's why. Well, with regard to the anti-discrimination legislation and also any efforts by the administration to ensure there will be equality of rights amongst the different bodies or different people, I would be prepared to support that. That's why I would be prepared to support the amendments proposed in the discrimination legislation, miscellaneous amendments bill 2018. On the 8 amendments, for example, a prohibition on discrimination on grounds of breastfeeding, and also for the reference to associates instead of near relatives, and so on and so forth. I support all of those. Well, I can see that in the amendment bill, the administration has heard members' views, and therefore I can see that in the amendments proposed by the administration, they have made some progress already. Yet I have to point out that if you look at the bill on this occasion, there are still areas that I find to be disappointing. Well, the administration has adopted a couldn't-care-less attitude when it comes to the EOC's recommendations, and I would actually suspect that the administration is condoning to discrimination and harassment. If you look at the present bill, well, the origin of that was back in 2014 when the EOC conducted a review and public consultation on the anti-discrimination legislation. And then in March 2016, the EOC submitted a review report to the administration, and some recommendations have been made to the administration. In the report, a total of 73 recommendations were made by the EOC, and they believe that some 27 should be given priority. And then out of those 27 prioritized recommendations, the EOC said that there should be 2 batches, and 22 should be the first batch, and then 5 would come under the second batch. And according to the EOC, they were of the view that for the 22 recommendations, they would be easier to implement, and the enforcement efforts would be less cumbersome. And for the rest, the administration would also need to conduct further consultation and so on. And on parts 1 and 2, in fact, the matters were equally important, and therefore it suggested that the administration should press ahead with that as quickly as possible. But then what happened next? The administration finally submitted this amendment bill involving some 8 recommendations, but then for the rest, apparently there is no end in sight as to when they would be tabled before this council. Well, if you look at the Bureau, at the CA Constitutional Affairs panel, they said that the administration would be giving priority to those less controversial parts so that they would move amendments only on these issues. And if I remember it correctly, they said that for the relatively controversial and complex recommendations, and if there are impacts on the policy level, and if the public have expressed diversified opinions or strong views on those, then the administration would need more time to study them more carefully. I agree. Yes, out of the 70 recommendations, some of them would be more controversial and complicated, and that's why it would take a bit longer for the administration to look into them. But then the EOC has already looked at the findings of the consultation, and they have adopted a multi-perspective approach in coming up with the 27 prioritized recommendations. And still, the administration is still screening these recommendations, and they've only chosen 8. And as a result of that, some 65 other recommendations would not have any way out as to how the administration is going to follow up on them. Well, being controversial doesn't mean that this is a sufficient ground for not doing anything about it. In fact, under the basic law, well, the CPPs, the IPPCR, and also the ISCRA, and also the International Labour Convention would also apply to Hong Kong, and they will continue to be effective in Hong Kong. And according to, they would also be implemented under Hong Kong's domestic legislation. But then if you look at the amendment bill, for the recommendations made by the EOC that have not been implemented, in fact, they are blatantly in violation of the International Convention and even the International Labour Convention. I'm not just citing this as academic discussion. In fact, if you look at the EOC report, they recommended that the administration should amend the DDO so that there would be expressive requirement for reasonable accommodation for disabled persons, for example, in the provision of services, goods and facilities, and also education and premises and so on. And according to the experience of the EOC, Well, for complaints filed by disabled persons, the number is the highest, and also their investigations also show that they have been facing a lot of obstacles and obstructions in terms of receiving education and so on. They have not been able to fully participate in these areas, and therefore, according to the EOC's experience, out of the 4 anti-discrimination ordinances, disability complaints has accounted for the largest number. Back in 2014, basically, they dealt with 716 complaints, and out of those, complaints in relation to disability would account for 35%, and for complaints raised by the disabled, many of them involve different areas, for example, employment, provision of goods, services, facilities, and also premises, and so on. So they did not have reasonable accommodation in those areas, and therefore, to provide for accommodation that would ensure that they would be able to take part in their daily life on an equal basis, and that's very important to them. And for the disabled to be able to get employment and receive education, that's also very important so that they would have a reasonable standard of living. And that would also hugely alleviate them so that they would not be living in poverty. But then, in modern days, we emphasize the importance that disability has been caused by social obstruction, and therefore we will have to remove those barriers. And this way of life has been accepted internationally, and accommodation has arisen from that concept. But then if you look at the DDO, well, there is no express provision that reasonable accommodation will have to be offered to those disabled. In other words, whether or not there is accommodation will not become a defense for the defendant, and for the employer's failure to provide accommodation, will that result in unreasonable difficulty for the disabled, and therefore you have not fully discharged your duty under the international convention. And when compared to other European and US jurisdictions, I think there is a discrepancy, and under the the relevant international convention came into effect in Hong Kong on the 3rd of May 2008, and the convention has already expressly provided for that. In order to promote equality and eliminate discrimination, the signatory to this convention should take appropriate steps to ensure that there would be reasonable convenience afforded to the disabled. And the ISCRA, the International Convention on Economic and Social Status, well, the refusal to offer accommodation to these people would constitute discrimination, and that should be regulated by the domestic legislation, and the authorities should resolve these problems, for example, in workplaces and also in public places or private venues. There should be reasonable accommodation, and only with appropriate layout design so that wheelchairs can use those premises more conveniently. And if there is any failure to do that, that would also cause obstruction to these disabled. And the convention also provides that the employers should offer or provide reasonable accommodation so that they can take part in their work, and they could also be promoted. Unless this would constitute unaffordable burden to the employers, the law should also expressly provide that the refusal to provide reasonable accommodation would constitute discrimination. And Hong Kong's laws have made reference to the similar legislation in Australia, and Australia has already amended the relevant definition on reasonable accommodation. On this occasion, if you look at the amendments being proposed, it would only look at the negative acts of harassment on this against disability, but then on reasonable accommodation, nothing has been done about it, and the administration has not interfaced with the updated legislation internationally. So the administration would give people the impression that they are actually allowing the employer to continue to do this, and this unfair situation that has been leveled against the administration is not totally unfounded. So for racial discrimination legislation, there are obvious loopholes. When compared to the other 3 pieces of legislation, these are loopholes under the law. Well, under the RDO, Section 3 provides that it should be binding on the administration, for example, in the area of employment and provision of services and so on. the administration would be bound. But then, unlike the other three pieces of legislation, there is no express provision to say that in discharging government functions and exercising its powers, if there is any discrimination against a certain race, it would constitute an offense. It shows that when the public get services from the administration, for example, at the Immigration Department, the police station, and also at the CSD, if they are discriminated against, they would not be protected. I can give you an example. For example, if a police officer arrests somebody on grounds of his race, then he would not be protected because the act of arrest can also be argued to be the police officer in this discharging his functions and duties and so on. That has happened because back in 2010, there was an 11-year-old homegrown Indian permanent resident, Mr. Singh, and he said that at the end, Wen Chai MTR station, when he came out from the exit, a Chinese adult held his neck, and then that guy claimed that Mr. Singh hit him, and he was sued for assault, and both called 999. And then the police did not investigate into that Chinese man. And then Mr. Singh was taken to the police station. He said that he could only speak English, but then he was arranged to have a Pongi interpreter. And under the RDO, they filed a complaint against the police for discrimination on grounds of his race. And then the fact that he was arrested and detained, and he was just an 11-year-old Indian boy, and that would constitute discrimination. And then in 2011, the case was tried, and Mr. Singh and his guardian lost the case. And the grounds for that was that the arrest and investigation would not be subject to Section 3 and Section 27 of the RDO. And this case law highlights that the existing protection is not adequate, and therefore we need to strengthen it. And the EOC also pointed out that in terms of actual operation, such acts would not be deemed to be services. In other words, in ensuring that the administration in discharging its functions and exercising its powers, there are obvious loopholes. And what is most unfair is that if you look at the RDO and when compare that to the other three pieces of legislation, the provisions are not the same. Because for the other three pieces of legislation, there would also be regulation on the exercise of powers and so on. But then for government officials to discharge their duties and exercise their powers, there has been no regulation whatsoever. So obviously, the opposition would come from the administration itself. And therefore, I have to point out that the administration has deliberately kept this unfair and unequal society. There are grounds for saying that, and therefore in promoting equality in our community, of course, that's not just the responsibility of the administration, but also the duty of everyone. This is a platitude. But then, when it comes to discrimination and deprivation of human rights, that's because of the imbalance in power. And therefore, we need to have policies and initiatives and the law to promote equality and balance in power, so that there would be checks and balances against the abuse of power. That's the reason why we have to have anti-discrimination legislation. But then what has the administration done? They have deprived everybody of their human rights, and it's an obvious violation or contravention of international contravention. But then they should have stopped when they noticed that there is abuse of power. But then what have they done? So they are actually contradicting themselves. They are acting in violation of this, because this is the most critical structure that is in violation of human rights. That's why, in supporting these amendments, I have to severely criticize the administration. These are my remarks.
Ms. Yong Ho-Yen. Madam Deputy, whether it be direct discrimination or indirect discrimination, any type of discrimination should not exist, because all discrimination will
give unfair treatment to others. Although we now have 4 anti-discrimination ordinances, which are namely Sex Discrimination Ordinance, Disability Discrimination Ordinance, Family Status Discrimination Ordinance, and Race Discrimination Ordinance, and to prevent acts of harassment, vilification, and offensive behavior against these ordinances, there are still many loopholes in the ordinances which do not protect comprehensive protection. Therefore, I am in the support of the discrimination legislation miscellaneous amendments bill to expand the scope of protection of these ordinances. We see that discrimination is very strife. Miss Claudia Mo questioned my capability to run for deputy chair while I was pregnant. And actually, many pregnant women see such sort of discrimination. In 2016, the EOC published 70 recommendations to the government after the discrimination law review, out of which many are considered by EOC to be of higher priority. Through the amendment, the administration has picked 8 to be of higher priority, including prohibiting discrimination on the ground of breastfeeding, both directly and indirectly, and to include a pumping of breast milk into the bill. These would be very effective to protect breastfeeding mothers. The WHO recommends breast milk to be fed to infants of up to 6 months. Some members have shared their experiences, and I myself also have this experience recently. It is very difficult for me to persist in breastfeeding for 6 months due to work, and maybe LegCo may not be accommodating in its facilities to support my breastfeeding for 6 months. I know this is a mother's responsibility. Although I am not able to fulfill this responsibility, I still hope other mothers will be able to provide breast milk to their babies for a longer time. In the past 20 years, breastfeeding women numbers increased from 51% in 1998 to 88% in 2018. And this is the breastfeeding percentage of mothers only just discharged from hospital. And then for those who feed up to 4 months or older, it has also increased from 6% in 1998 to 29% in 2018. Although more and more mothers prefer to breastfeed their children, we still hear that the community facilities are not adequate to support breastfeeding. The policies and the public's attitudes all need to improve. We hear many mothers complaining there are not enough baby care rooms, and some mothers find it difficult to pump milk at the workplace. Their employer will complain about them spending too much time or taking up space in the refrigerator at the workplace. And I see that the government has taken measures in promoting breastfeeding and in promoting breastfeeding friendly premises and breastfeeding friendly workplace policy. In 2019, there are around 130 places that are named breastfeeding friendly premises, but is 130 a huge number? It is actually not. It is quite a low number. Aside from these public spaces, the government departments have also improved their 324 baby care rooms in order to step up their facilities since early in the 2010s, and you have now seen more spaces allowed for breastfeeding mothers at the workplace. The government, starting from end of 2018, in their conditions for land sales also include that condition of providing breastfeeding friendly workplaces to the people. We mentioned in 8A of the amendment, any direct or indirect discrimination against breastfeeding will be in violation of the law. We understand that the sex discrimination ordinance is not very broad. It's a very narrow ordinance. It's only related to employment, education, service providers, and premise management, and also related government activities. Perhaps you would also remember that I did lodge a complaint against Claudia Mo for discriminating pregnant women. Some members criticized me whether I have correctly used the sex discrimination ordinance, and maybe it wouldn't be appropriate. Of course, we all know that you need to collect evidence on whether it is direct or indirect and whether there is actually an employment relationship. This ordinance stipulates that there should be no discrimination against pregnant women and breastfeeding women at any time. It shouldn't be at specified premises only. The ordinance itself needs to meet an objective. In the newly proposed 8(a), breastfeeding, pumping, and also pumping breast milk is also considered, or expressing breast milk to feed a child is also considered as breastfeeding, especially for those who continuously work during their breastfeeding period. And that is of some sort of help, even though the scope is still very narrow. Just now I mentioned direct and indirect discrimination and the definition of these terms. There have been many deliberations on what the definition is for direct and indirect discrimination. There is no mention of any employer or service provider having the responsibility to protect their employees and in accommodating the employees in their needs, as long as the employer or the service providers could prove that there is a reasonable excuse and it would not be construed as indirect discrimination. For example, when you're talking about resources for breastfeeding women or the scale of their businesses, or whether there would be any difficulties in the employer in providing accommodation, then it will be discrimination. But then you will need to provide evidence in order to do that. Let's take a look at the UK's Equality Act 2010. We can see that it is considered as sex discrimination if you discriminate against breastfeeding women. No one should harass them or deny services. Otherwise, that would be in breach of the law. That is much clearer than our amendment in Hong Kong, and actually it covers a very broad scope. I hope that in future, when the government has the opportunity to once again amend the legislation, then it could be in a much broader range. And we can also make reference from overseas legislations. In our Bills Committee, we also focused on the discussion on harassment, on breastfeeding mothers. Well, we are not only looking at discrimination. That may be a verbal discrimination, but for a harassment, it's actually much more different. Some of them may be oral remarks, some of them may actually be the way they stare at breastfeeding. So here we talk about harassment and vilification. There are definitions, however, and which I would elaborate further. However, I'd like to talk about a case in 2016, a working male employee and a breastfeeding mother. A breastfeeding mother put her breast milk in the refrigerator in the pantry, and the male employee stole the milk for his own consumption and sent out harassing messages to the female colleague. So I thought about whether this amendment could assist in this female colleague. In 2016, however, the male colleague was only sued under burglary. But then for breastfeeding mothers at the workplace, this is obviously a sort of sexual harassment, and there were no provisions to provide for that in 2016. Even today, without amendment, it cannot help that female colleague. Well, we've discussed it for 2 years, from 2018 till now, yet we're still not able to help this female colleague explain to the public that actually this sort of harassment is considered as sexual harassment. In our amendments of the bill, earlier this year, the administration submitted the 2020 SDO amendment, which refers to harassment on breastfeeding women. Well, I'm sure you understand why we're still not able to submit this bill up to Council, which is because of the standstill of the House Committee, that we were not able to put the amendment bill up for even a first reading. There are many legislations still at the HC level, and the harassment ordinance will not be able to see any results in this legislative session because of all these standstills. I hope we'll be able to work on this in the future. However, I don't have hope for the bill of sexual harassment being discussed here. I see the EOC has given many recommendations on the full anti-discrimination ordinance, and I hope that these could all be realized. I encourage the EOC to continue to share with us their views, and I hope they would also proactively continue their suggestions on these ordinances. I speak in support of the Discrimination Legislation Miscellaneous Amendments Bill 2018. I so submit.
Does any member wish to speak? Mr. Dennis Kwok. The United Nations special report offices compiled a special report on anti-discrimination legislation. They sent a letter to the administration in February that out of the 4 discrimination ordinance, the race discrimination ordinance does not cover acts of discrimination committed by the government in the performance of their functions. That means the government can make decisions or commit acts that constitute race discrimination. These 2 special rapporteurs of the United Nations said in the letter that this has greatly undermined the effectiveness as well as the scope of the Great Discrimination Ordinance. We're here to talk about the Discrimination Legislation Miscellaneous Amendment Bill 2018. Regrettably, there are a lot of areas that are in great need of change but have not been changed. On the 11th of February 2020, a letter was sent by 2 UN special rapporteurs. I want it to be on the record. It says, I quote,
"We would like to bring to the attention of Your Excellency's government's information that we've received concerning the Race Discrimination Ordinance, RDO. Of the 4 anti-discrimination ordinances in Hong Kong, the RDO is the only one of limited scope. Unlike the other ordinances, the RDO does not apply to all government functions and powers. We are concerned that these government exemptions to RDO undermine the right to equality before the law, limit the scope of the protection, and permit discrimination on the basis of race, ethnicity, and national origin, and impede racial and ethnic minorities' access to justice." 封信呢繼續就咁講。
It continued to say,
RDO exemptions prevent equal protection under the law and equal access to justice. The Equal Opportunities Commission investigates complaints, facilitates mediations, and pursues legal action against offenders. It appears that RDO's exemptions impede the EOC from carrying out its mandate because the RDO does not apply to government functions and powers. An individual alleging racial discrimination by the government is unable to access the EOC's free complaint mechanism. According to information received, such alleged victims of racial discrimination are obliged to pay expensive court fees and pursue litigation. However, the litigation is not a viable alternative for many potential victims of racial discrimination. Statutory exemptions and limited scope of the judicial review reportedly pose immense barriers on racial and ethnic minorities' access to justice and protection under the law. Only one case has been adjudicated under the RDO. This is the Singh Arjun versus Secretary for Justice case. This case demonstrates how the RDO's limited applicability to government functions and powers creates an inequitably high legal threshold for victims of racial discrimination and fractures the protection of fundamental rights and freedoms of racial and ethnic minorities in Hong Kong.
in relation to this, I hope that the administration realizes that because of the restriction under the RDO, there are many unfair incidents occurring in Hong Kong, it says.
The Elimination of Racial Discrimination, CERD, has previously expressed similar concerns, urging the government to amend the RDO to bring the law in line with international standards. During a 2018 session, CERD reiterated its concerns that in Hong Kong, China, law enforcement activity does not necessarily fall within the scope of the prohibition on racial discrimination in the Race Discrimination Ordinance. The committee recommended that Hong Kong amends its domestic laws to expressly define and criminalize all forms of racial discrimination in conformity with Article 1 of the Convention and expressly prohibit both direct and indirect racial discrimination in all fields of public life, including law enforcement and other government powers. 當大家睇到喺美國
Well, in the George Floyd incident in the US, in which he was being pinned to the ground by a police officer who used his knee to kneel on his neck, it has brought to a lot of people's attention about race discrimination. It's high time that we look again the letter sent by the UN in relation to the inadequacies of the RDO. It also says in the letter,
RDO, the exceptions in the RDO alone give rise to serious concerns that executive powers in Hong Kong may discriminate with impunity. Barriers to EOC adjudication and to litigation concerning the RDO, failure to amend the RDO, and the ruling in Singh Arjun versus Secretary for Justice jointly exacerbate these concerns and undermine racial and ethnic minorities' enjoyment of human rights in Hong Kong. Recent incidents involving police use of force during protests motivate particular concern about the RDO exemptions. We have received reports that police in Hong Kong frequently subject racial and ethnic minorities to racial profiling. Racial and ethnic minorities are allegedly stopped, hassled, and detained by law enforcement based on their perceived race and ethnicity. Such unequal application of the law can create profound distrust between over-police communities and law enforcement.
This letter is mostly about the exclusion of the police force and other government organizations from the RDO. It will give rise to a lot of problems. In this letter, there's also a footnote. It is an annex covering about international human rights laws, as well as elimination of discrimination on the grounds of race. I'm going to cite the main points.
Alleged facts concerning government exemptions to race discrimination ordinance, we would like to remind Your Excellency's government of its international rights and obligations. We would like to draw the attention of Your Excellency's government to the human rights and norms and standards delineated in the International Convention on the Elimination of All Forms of Racial Discrimination, acceded to by China in 1981, and the International Covenant on Civil and Political Rights signed in 1998. We would like to emphasize that the state party must guarantee non-discrimination and equality, take effective measures to amend or eliminate racially discriminatory policies, and provide effective protection and remedies. The inherent dignity and the equal and inalienable rights of all persons is rooted in the Universal Declaration of Human Rights, Articles 2, 3, 10, 11, 12, 13, and 18 of the UDHR, provide for the principle of non-discrimination and equality, rights to liberty, security of a person, to be recognized as a person before law, to be equal before the law, and receive equal protection of the law, to have access to effective remedy, to not be subject to arbitrary arrest, detention, or exile, and to have equal access to a fair and public hearing, the presumption of innocence until proven guilty, and to not face arbitrary interference with privacy, family, and home, to freedom of movement, and to leave any country, including one's own, and the freedom of religion and belief. In the General Recommendation on Discrimination Against Non-Citizens, the Committee on the Elimination of Racial Discrimination clarifies that under the Convention, different treatment based on citizenship will constitute discrimination if the criteria for such differentiation, judged in the light of the objectives and purpose of the Convention, are not applied pursuant to a legitimate aim and are not proportional to the achievement of this aim. The recommendation also calls on states to ensure that implementation of legislation does not have a discriminatory effect on citizens. We express apprehension that the exemptions to the RDO, 講緊香港嘅呢一個反歧視種族
This applies to the RDO in Hong Kong.
Party's obligation to ensure formal and substantive equality in the enjoyment of these rights. We would like to call attention to the international standards concerning the protection of the rights of persons belonging to minorities, in particular Article 27 of the ICCPR and the 1992 UN Declaration on the Rights of Persons Belonging to National or Ethnic, Religious and Linguistic Minorities, which outlines states' obligation to protect the existence and the identity of minorities within their territories and adopt the required measures that persons belonging to minorities can exercise their human rights without discrimination and in full equality before the law. 嗱，講返而家嗰個條例咧，除咗係
There are some people who have made comments on the performance of the chairperson of the ECO. He has made some discriminatory remarks. I don't want to repeat these remarks. That person is the chairperson of the EOC, the Equal Opportunities Commission. Making such discriminatory remarks is appalling. I asked him if he would retract these remarks or if we would reflect upon what he said. He refused. A lot of people from the ethnic minorities told me their great disappointments towards this chairperson. Well, the EOC has been seeing that the government is dragging their feet to take up the recommendations, they should done them. Say, for example, in relation to Clause 4, to ask for information of the aggrieved party. I received a reply from the EOC. They said that the aggrieved party may seek assistance from the EOC, who would then assist the aggrieved party to seek information. That means they would have had the right to seek justice through the EOC, but in reality, they can't do it. So they should do their best to follow up on the issue of the request for forms. For these discrimination ordinances, in relation, especially about the RDO, there are many problems. They should be dealt with once and for all. I find it very regrettable that they have not been followed up.
Ms. Claudia Mo. Well, point of order, Mr. Ray Chen. Yes, I'd like to make a call for quorum. We have already formed a quorum, so we will now continue. Ms. Claudia Mo.
Discrimination legislation bracket miscellaneous amendments unbracket bill. It's very obvious by now if you look at this bill very carefully and what's miscellaneous about the amendments, that this government is simply half-hearted about trying to erase discrimination in this city. Now, to start with, in this council, we've heard members accusing or calling each other all kinds of names. You're fat, you're stupid, you're lying, you're a liar, you're all maggots and worms and what have you. One would tend to dismiss all that as sheer political exchanges, that they are just said for the sake of debating, political debate, you understand? Although technically, if you look at all those statements legalistically, they just might easily fall under racial, gender, sexual biases. A lot of them. But then, if you look at this bill, you could see all the gaping holes, but instead of addressing such huge holes in all these supposed new legislative protection, we've got this a woman member of this council accusing me, mother of two, of discriminating against her at this council, that she was pregnant at a time when she was very advanced in her pregnancy and she was about to give birth fairly soon after, that she should consider getting more rest at home, that she should stop straining herself. But this is, to call all that ludicrous, frivolous, petty, is simply to say the least. Now, I was talking about gaping holes in this bill at hand. Though, what are the big holes? The biggest I could see is about racial discrimination. A young Indian boy once took the Hong Kong police to court for racial discrimination. What happened was he was a young man by the time the court case finished. But when it happened, he was barely 11 years old and he was traveling inside the Wan Chai MTR station. He was in a hurry and dashing up some escalator and inadvertently pushed some apparently ethnic Chinese woman, an adult of course, and some row ensued and the woman and the boy both called 999 for the police. The police came. The woman just got off. They completely ignored her. Nothing happened to her. They just let her go. And they would arrest this 11-year-old Indian boy. They took him back to, of course, Wan Chai police station and detained him for more than 5 hours. But then no charges were filed against him at the end of the day. And so the boy accused the police of racial discrimination. His case took a total of 20 months to try. And ultimately, he lost the case because according to our racial discrimination ordinance, he has no grounds to criticize the police. The police was doing their arrest work, their police work. The police is not providing service as such. And according to our ordinance, all police department functions and officials' exercise of powers are exempted from this racial bias law in Hong Kong. So please, could you not fill the hole? No, it's too complicated. They wouldn't do it. However, at the Bills Committee, we debated and urged. I think nobody has countered the opinion that this hole must be filled up altogether. But then the government just said, bye-bye. That's what we've got, like take it or leave it kind of attitude. They just want to do the easy bits of the job. The EOC, the Equal Opportunities Commission, actually named or suggested a number of legislative proposals, but the government ignored most of them and selected, literally, they are very selective with their legislative amendments. Let's do this one because it's fairly easy. It's uncontroversial. And so, when it comes to racial bias, and if it involves any government department or any government official, or they could claim that we are performing our functions and we're exercising our powers. And as a result, what they've done is exempted. It's excluded from the racial bias ordinance. So how more safe can a government be? How could a government introduce something new on the legislative front, but making it sure at the same time that the government itself will get awfully jolly protected? Discrimination, somehow civil servants are allowed to do such things because they're protected, or they're somehow above the law. Functions? What functions? Well, when they're dealing with ethnic minority Hong Kongers, and they can pretend that there's nothing racial about it. I just don't speak English, or maybe you smell and I don't like it. It's nothing racial there. This is completely absurd. And even more ridiculous is there's a new EOC, Equal Opportunities Commission chair, suggesting that there is such a thing as indirect racial discrimination. Now, give me a break. That's really exhausting. It's almost exasperating. Now, when it comes to racial bias, it's racially based. I've more than once asked the officials sitting there, racial bias, right? So it's all about race. It's race-based. You agree, and they agree. Okay. But then, when it comes to some, those yellow circle shops refusing to do business or receiving as customers mainlanders, they claim they can't understand mainland Chinese, 普通话, basically. Now that's not, probably to most people, it's not a very nice attitude of doing business, but we are in a free economy. Okay. You would say, let's make sure that Hong Kong is a tourist haven and will be nice to all tourists, whatever their background, their ethnicity, their nationality, and so on and so forth. No, the EOC chair would go way up to call that indirect race discrimination. It's such hyperbole. I just can't describe my feelings when he suggested that somehow, in his eyes, Hong Kong people and people from mainland China are of different races. Isn't that scary? Just what's he trying to suggest? One good example, what I read in some UK government anti-racial bias website was, you're a UK employer. You want to hire somebody who can speak native English. And by that, some Ukrainian Briton came to apply for the job. And because the Ukrainian spoke English with some sort of accent, you had to tell him to go away. He could turn around and tell you, accuse you of indirect racial bias. Because you didn't mean to tell him to go away simply because he's Ukrainian. It's got nothing to do with his nationality. But the fact is, he couldn't speak the sort of native English you require. So it's discrimination of a sort, but indirect. But it's still race-based. He couldn't speak native English because it's not English. That's the whole point. So I don't know what this EOC head has become about racial discrimination, but that's such a minor thing. He shouldn't have even bothered about it. It's nothing to do with ethnicity or racial issues. He should have looked at why the government is basically exempted from this race bias ordinance altogether. And it's nothing new. We've been talking about this for at least 7-8 years. And another gaping hole in this new bill is the government's refusal to address the problem of providing what you call reasonable accommodation under the Disability Discrimination Ordinance. Now, reasonable accommodation, it's all reasonable. And our welfare colleagues, our welfare-focused colleagues have made it very clear. It is under this very disability ordinance that most complaints were lodged because they got so discriminated against. And there was no way to actually have their complaint addressed. I mean, of course, you can always complain, you can moan from here to hell and back. Nobody would pay that much attention to you. This reasonable accommodation is about not just being sticklers. You can't just say, oh, this is the law here, this is the rule there. We have to do things by the book. So you can't bend the rule and you can't twist the law, and it is what it is. No. Say if a certain premises is actually off limits to animals, say here, this chamber, no dogs allowed. But if somebody a blind person would need to come in here with a guide dog, I don't see anyone would ever object that, the dogs are not allowed in. Impossible, right? That's what we call reasonable accommodation. But even this, a huge thing for the handicapped, but actually a minor thing for those who would have the authority to change the law. they still prefer to ignore it, at least for the time being. So this is very disheartening. Thank you.
Does any other member wish to speak? If not, I now call upon the Secretary for Constitutional and Mainland Affairs to reply, then the debate will come to a close. Secretary.
主席，首先我藉此機會感謝2011
Madam Deputy, first of all, I'd like to take the opportunity to thank the Chairman of the Bills Committee and all members of the Bills Committee for having discussed the bill for 5 times and completing the scrutiny work. And on the 8th of May, the Bills Committee submitted a report to the House Committee. Next, I'll be summarizing the content of the bill and also the amendments to be moved by the administration and also respond to some of the comments made by members just now. After considering in detail the comments made by the EOC after the review on the 4 pieces of anti-discrimination ordinance, we have submitted the 8 prioritized recommendations. We have come up with the amendments proposed for the 4 pieces of anti-discrimination ordinances, including the SDO, the DDO, the FSDO, and also the RDO. And they include 1. Introducing express provisions prohibiting direct and indirect discrimination on grounds of breastfeeding, including expression of milk and also the status of women in breastfeeding, and also enabling the protection against racial discrimination and harassment to cover not just near relatives but also associates, and also protecting people from discrimination and harassment by perception or imputation that a person is of a particular racial group, and also expanding the scope of the relevant legislation to provide protection from sexual, racial, and disability harassment to persons in a common workplace, and also strengthening the protection for service providers so they will not be subject to disability and racial harassment by service users. And on board of Hong Kong registered aircraft and ships, even when the harassment takes place outside of Hong Kong, disability and racial harassment shall be prohibited between service providers and their customers. And also protecting club members or prospective club members from sexual and disability harassment by management of clubs, and also aligning the claims provisions of the 4 pieces of anti-discrimination legislation by repealing the provisions which require proof of intention to discriminate in order to award damages for indirect discrimination claims, so the courts will have greater flexibility to deal with such claims. On top of that, we are also going to move some amendments in order to ensure that the protection afforded by the legislation will be more comprehensive. These would cover 2 areas. First, amending the definition of breastfeeding so that the protection will not apply only to women breastfeeding their own children, but also those breastfeeding any child. And 2, under the provisions prohibiting sexual, disability, and racial harassment, express provisions will be added to afford protection for interns and volunteers. An appropriate regulation will also be put in place on vicarious liability and disclaimers. Upon the commencement of the amendment bill, the relevant legislation will afford clearer protection towards lactating women from discrimination. This will also create a more conducive environment to enable breastfeeding women to continue to participate in social and economic activities more comprehensively and equally, including the ability to continue with their employment or rejoin the labor market. To enable the employers and the relevant parties to have sufficient time to prepare for this, the administration or the amendment bill will come into effect 1 year after the Gazzetto, and the EOC will also come up with guidelines for employers. Moreover, the bill will also afford better protection in terms of racial discrimination and harassment, which will go a long way in promoting racial diversity and inclusion, thus enabling different racial groups and ethnic communities, families to establish a closer and more inclusive social network. In the area of employment, the amended provisions will enhance protection for service providers and their customers in different trades, and the newly added commonplace protection will cover different work capacities more widely, which will help improve the situation of workplace harassment. Madam Deputy, in the course of scrutinizing the bill and also in the remarks made by members just now, we have also received some suggestions on areas that have not been covered in the amendment bill. With regard to the recommendation made by the EOC on the prioritized recommendations, including amending the RDO to prohibit the government from racial discrimination in performing its functions and exercising its powers, and also amending the DDO to require the making of reasonable accommodation for persons with disabilities in all relevant fields. The administration will continue to look into them seriously and take follow-up action accordingly. As to those classified as subjects requiring further study, consultation, education, such as the protection against discrimination against citizen status and also resident status, in order to deal with discrimination against new arrivals and visitors from the mainland, and on discrimination against cohabitation, we believe that these would warrant further study, and we have also noted that there are suggestions that are outside of the EOC's recommendations. We will take note of them, and we will refer to them in future reviews. In response to the Bills Committee's comments, we have already separately submitted the Sexual Discrimination Amendment Bill 2020 to broaden the scope of protection under the SDO to prohibit harassment on grounds of breastfeeding. That bill was gazetted on the 31st of January 2020, and yet because of the shutdown of this council in the face of the epidemic, we have not been able to continue with the first reading and second reading, and in next term of this council, we will consider how we can review the work and implement the measures as quickly as possible. The Bills Committee also discussed other issues in relation to the SDO. For example, some members were of the view that sexual harassment between students from different education institutions should also be covered, and there should also be effective measures to deal with sexual harassment between pastoral staff and congregation in churches, religious facilities when they participate in religious activities. We have invited the EOC to comprehensively review this application of the relevant provisions and see how we can better protect these concerned parties. We'd like to thank you for your concern on anti-discrimination work, and I move that the Discrimination Legislation Miscellaneous Amendments Bill 2018 be read the second time, and we hope that with the passage of this bill, we'll be able to strengthen our protection for women, ethnic minorities, and also employees, so that they would not be subject to discrimination and harassment in the relevant areas. These are my remarks. Thank you. I now put the question to you, and that is Discrimination Legislation Miscellaneous Amendments Bill 2018 be read the second time. Will those in favor please raise their hands? Mr. Ray Chan has called for division, so the bell will ring for 5 minutes.
開始表決。
Voting begins. Please check your votes. If there is no question, voting is closed, and the results displayed are 54 present, 53 for, no against, and no abstention. I think the question is agreed by a majority of the members present. I declare the motion passed. Discrimination Legislation Miscellaneous Amendments Bill 2018.
全體委員
This council now becomes committee of the whole council to consider the discrimination legislation miscellaneous